but can you see this okay?
Yes.
All right. And if there's a question, just unmute and you can read me the question.
Okay.
All right. Okay, everyone, thank you so much for attending. This is wonderful because, like I said, we're in an unprecedented time, and it's just you learn one thing that works and then the next day it's changing. So we came up with this webinar. It's called Bulletproofing Your Brand: How to Stop Copycats and Knockoffs on Amazon and TikTok Shop. Quick disclaimer, obviously, a lot of you are lawyers, so you know it's just educational information purposes. We're going to give you some case examples of things that have worked. Prior results do not dictate or guarantee future guarantees or similar outcomes for the future. Some of the pictures we used are actually AI generated. So it's cool because there's no copyright and we didn't need to get permission, but I'm just saying that as FYI, some of this stuff is it is AI generated, so it's not actual screenshots of the USPTO or Amazon, but we didn't want to use any client information or any other third-party brands, so we used ChatGPT. Okay, so the counterfeiting crisis, it used to just be Fortune 500 companies that have been dealing with these problems, but all of that has changed radically with Amazon and TikTok. Social media, people thought that it was for kids or it was for college kids. Then the masses got on, adults got on, but then businesses got on. So once businesses realized that this is a way to reach people, brands got on there. So did the criminals. So a brand will go popular. These are companies that make anywhere between $1 million to $100 million in revenue. They're considered mid-sized companies, and they are also called emerging brands, which we'll talk about. But they're these brands that go viral on TikTok or Amazon, and all of a sudden, in a matter of weeks, really, they're getting knocked off. And if there's one knockoff, there's more coming. So what's happening in China and overseas is there are people who are literally watching just to steal your client's intellectual property or your intellectual property and knock it off as quickly as possible before you hire lawyers, before you even, or before you're engaged, if you're a lawyer, to do this. And then if you are a lawyer, clients are hiring you saying, this is eating into 40% of my sales online. I need this problem to stop immediately. Many clients, unfortunately, when it gets to that point, they're like, I don't care what it is. We have to solve this. Let's figure it out. And the whole point of this presentation, like the main takeaway, is you cannot just do one thing. So whether you're a brand protection provider, like a software platform, relying only on takedowns isn't necessarily going to stop the problem. If you're a lawyer and you're a litigator, only litigating is not going to necessarily stop the problem. It is a comprehensive, multifaceted approach that is important to building out these programs for clients so that they can sleep at night. You have a software that's running, scanning the internet. You have a process in place where you're analyzing them, putting them into certain buckets and determining whether or not you're going to do a lawsuit versus a takedown versus a cease and desist letter, or send it out to investigators to investigate and try to shut down the physical store or the physical warehouse. So obviously it's a huge point, and I have some statistics here. For any of you who have not yet seen TikTok Shop is separate and apart from TikToks. It's only on the app, which makes it really hard for software companies like Copa, who's on here. Will and his team are, which we'll talk about Copa because we work with them. They're a software vendor that scans the internet for fakes and puts them into a portal to execute takedowns and escalate to lawyers when needed. But TikTok Shops literally does, you can't scan for it on your, on the web browser, which makes it really hard to do that type of auto detection. These are some high risk industries, but I will say, I don't think anyone's immune. We've some of these for you so that if you do get clients or if you are in this industry, talking to them early about this problem is better than waiting. And what we try to do, of course, people really wait until there's a lot of pain, unfortunately, And when that happens, it's really expensive and you're forced to build out the IP protections at the same time of enforcing. But if you have these types of clients, you can advise them early, or if you are this client, like doing this early is going to save millions of dollars by having the right intellectual property protections up front, not just in the US, but also abroad. And monitoring using a software detection platform like COPA.ai, and also monitoring the trademark databases to making sure that your name is not getting stolen on as a trademark in different countries. So this is that group I was telling you about. And these emerging brands are the new victims. They're profitable. They're anywhere between, $1 million to $100 million, but they are startups and cash is king for them. Cash flow is important. They're consumer product based. They're spending a ton on digital ads a month to get in the volume, and they are absolutely willing to contribute to their brand protection budget, but it's harder and it's not. We need to think differently as lawyers on just the hourly, not even the hourly rate necessarily. Billable hours are here to stay, but how can we work efficiently using technology just to be more efficient and effective for some of these smaller clients that can't necessarily afford 5-10 million a year in brand protection because they're only making 5 to 10 million a year. But that said, they still have some budget. So really, what's the solution? And for us, it's using technology and having this comprehensive program. And we talked about this. Brands go viral overnight. The other thing is I'm sure you're seeing word marks alone are not enough, because the knockoffs now will remove the word mark. And how do you go after infringers if they're not using the brand? You can file for trade dress protection or a brand and you're not sure. Like I'm happy to chat with you to see how you can use trade dress as a tool. Also, EU and UK designs are a wonderful tool because you can actually do takedowns based on them on some platforms. And so you may have knockoffs that are in the EU and the UK, and you could be using EU designs to take down as well. And those are great, also an underutilized tool. And copyright, you can use copyright for marketing photos, or if they're taking product photos and using those, or your product descriptions. That's another tool to clear up some of the low-hanging fruit. But some of the problems we see is this is a game of whack-a-mole, and it's an important game. So using the traditional whack-a-mole with takedowns in conjunction with some of the other tools we're going to talk about is critical to the enforcement playbook. So yeah, I can say it, like, we've developed a streamlined strategy to help protect brands. And I am happy to share this with you, whether you're a brand or you're advising brands. So, and this is a little bit about us. We're based in New York. We now do IP prosecution, enforcement, corporate agreements, litigation. Most of our lawyers, I would think actually all of our partners are either big law or we're in-house at big companies. And our whole model is to just be fast, efficient, and use technology to still give that like high-level service, to still give that high-level, top-tier service for clients while doing it effectively to keep their budgets down. Oh, I love this, Cassidy. This is cute. We're brand bodyguards. That's cute. So we work with COPA.ai to build online portals for our clients. Will is on here. You should absolutely connect with him offline or on LinkedIn if you're thinking about implementing this, whether you're a client or brand or you're an attorney. So this is a screenshot, but basically it scrapes the internet. It finds infringing listings. We have a dashboard of data that the clients like to see. And now we have a tool that's working for us 24/7 while the founders are able to sleep and focus on other things. Because that's like the biggest thing, is they are so stressed, and it prevents them from creating. There's such a drain in energy and emotion and resources too that come with this. So if you can build programs for them, and if we can build programs for the brand, if you're a brand, that is something that's going to allow them to say, okay, noted, I'm a popular brand. I understand this is just the name of the game. I'm leveling up, right? Part of scaling and getting to that next level just means dealing with more issues, unfortunately, as someone who owns their own company who is scaling. So it's, all right, we're never going to get rid of these problems, but how do we make it systematized so that we have a program in place that isn't putting us out of business to fund, while it's getting us some solutions and also hopefully getting you some recovery, which we'll talk about. So here are some success stories. We work with a beauty brand. We shut down over 1,000 infringing product listings. We had court orders restraining more than 100 different sellers, and we recovered over $500,000 in just 8 months for a client using litigation tools. And we've also had very high success with cease and desist letters for some big competitors. And we won a domain name dispute to get back their trademark, to get back their .com that was using their trademark. And there's another consumer brand product where basically her lawyer said there's not, the lawyers that she had and then other lawyers she consulted with said there's nothing you can do. It's a generic product. Sorry, you missed the design patent window. You're SOL. But when she came to us, I actually had the product and was like, I disagree. I think that there's something here. Maybe it's a more narrow claim, but let's come up with a creative strategy. And we were able to actually register the trade dress without getting any refusals on the first shot. We packaged everything right at the get-go with the application. So it ended up proceeding after that without ever receiving a refusal, which was cool because when we went to go fight it in court, that was a big deal. The judge continued to defer to the USPTO, and we were able to secure over $1 million in judgments for this client. So this is our, I don't know, you guys know me, a lot of you know me, I like marketing, I like branding. So here's a fun little acronym. And this is all stuff that lawyers know if you're in this space, but having this little checklist in mind is going to remind you of constantly doing these things as you grow and build brands or as you grow and advise clients. So number one, evaluate. You should be continuously auditing the brand to see what intellectual property protections do they have and what's protected and what's not and where. So reviewing the portfolio at least annually, if not quarterly, and seeing what IP do they have, where are their gaps, and what do we need to file for. Then number two, S is for secure, continuously filing applications instead of doing it retroactively, where we have clients that come to us and they have, multi-million-dollar legal problems. They have only one patent and one trademark, and now they need to fight counterfeiters and knockoffs across the globe. We are racing to file applications to register their IP worldwide, and it's wildly expensive versus if you're doing this early upfront and as a part of the process and reviewing and evaluating to see what IP to file every quarter, that would end up saving a lot of money and doing it more strategically, not having to pay this huge lump sum upfront trying to get things registered. And then we have C, which is combat, fight, enforce. So enforcement we'll talk about. We have a method on this piece on how to combat. And then A is, this is amplify. In our social media driven world, I think lawyers don't really think about this, but it's absolutely critical. If you're a client and if you're a brand that's going to be spending millions of dollars doing enforcement work and getting these big judgments, you damn well should be promoting it and amplifying this, because the infringers are in networks, the counterfeiters are all in networks, and they message each other on WhatsApp and WeChat saying which brands have filed litigations and who's enforcing rights. So the whole purpose of this is to deter bad actors from knocking off your brand and moving on to someone else's. So by amplifying it, creating a social media campaign strategy, we did this with Overnight Blowout. It's public. You can go to my page at The Trademark Attorney and look to see some of their videos they did. And also then doing a more traditional press release route is good because you get the Google traditional SEO and then in conjunction with the social media SEO, because yes, you better believe that the infringers and counterfeiters are on TikTok. This is all they do. They're scanning to find the next hot product. So if they're seeing a brand that is talking about how they just sued thousands of stores and recovered millions of dollars, that is going to deter them from picking on your brand. And it also, they then go and they share the word with their channels to not knock off your product because you have good lawyers. So I think I talked about this. And if anyone has questions, Madison, feel free to stop me. Because I can't see tech. I can't see the chat. So audit your IP portfolio, identify gaps, monitor platforms globally, spot infringement early. This was a fun, this is not real. This is AI generated. It's crazy how real it looks, but we're giving you an example of brand Surekind for dietary nutritional supplement. So this is a very traditional one, right? You're seeing wordmark and product packaging knockoffs. Where it's tricky is if a product isn't protectable, like the bottle shape or the packaging. So if your brand or if your client has some sort of distinctive elements, I would say go the copyright trade dress route and encourage them, if they are at the inception, to really develop that distinctive, identifiable product packaging or design, so that in anticipation that the knockoffs will change the name. Like maybe you could go after Surekind, but you may not be able to go after Safekind or Purekind. Maybe Purekind because it's one letter off. But these are the things. You never want to rely on just one tool, which is the word mark. You want to have multiple tools in your IP toolbox to go after. So registering, when we talk about secure, really getting US Patent and Trademark Office filings, patents, trademarks, also copyrights, but then customs. Customs is a huge thing that I think most lawyers miss also, and it's an easy thing to do. When your mark registers, recording registrations with customs is critical, but it doesn't just stop there. You have to actually train customs on how to enforce rights. So creating an authentication ID manual that sets out how to authenticate the products from the brand is key. And then actually meeting with customs to train them. You could do in person or you could do virtual. Combat. So we'll talk about our Knockout the Knockoff system, which we just filed for. Thank you, Madison. So it's these three things. And you think that this is not rocket science, right? But I think the main takeaway and why this is different is how you use these. And what has worked for us, let's see if I talk about this later. Yeah, I'm going to talk about this. I'm going to go right to Knockout the Knockoffs. What has worked for us really is starting with building out that portal, like using Copa.ai to pull all the listings in the portal, and then assessing them, figuring out who are the hardcore infringers that you want to go after, and really working with the brand, because this is where the strategy piece, it matters. And something that a lawyer thinks is concerning may not be as concerning for the brand. We're especially seeing this with TikTok. Things that, it's high volume operators. So people who are selling hundreds or thousands of units, yes, that's a problem. But it's not just that anymore. It's how many reviews do they have? What are people commenting? Are they running paid ads? So this is a big one. That's for some of our clients. They're like, okay, these people are running paid ads. They obviously have a bigger enterprise going on, but also they're beating us out. And that's the problem, is these knockoffs and counterfeiters are making more money than the brand. And you'd be surprised when we go to send cease and desist letters, we're literally getting responses back from some of the world's biggest IP firms. Gone are the days where like a reputable IP firm doesn't accept cases from knockoffs. If there's a colorable claim, right, they're representing them, because these are people who are giving large retainers, most likely. So that's what this is like the focus, is the strategy, and then figuring out which ones are most egregious in accordance with the client's concerns, putting them into this bucket for Schedule A litigation, People do it differently, but again, like we're going to share our method. What we believe works best is prioritizing these types of litigations. We did a sniper shot approach that we talk about with another client where we were really under the radar. We didn't do takedowns. We just focused on preparing these Schedule A cases so that as soon as we were ready, we were able to get temporary restraining orders, freeze the assets in the accounts, and negotiate with the sellers to get back money to give to the client. So I'll take a minute to define Schedule A litigation. Schedule A litigation is regular litigation, but you are allowed to basically put multiple defendants in a case because they're linked, and you're telling the judge that these are overseas sellers, or there's something about the sellers that if we put them on notice, they're going to leave and flee the country and take all their money with them. So we want to do it kind of under seal and not give them notice. So you take these cases, you bring them to the judge will grant the temporary restraining order if you do them well and right. And we know that judges are pushing back on this now, but we've kind of figured out how to do them well to get the results we want for the clients. And then you take that temporary restraining order, you serve it on the platforms like Amazon, TikTok, Shops, and Alibaba, and they will work with you to freeze the funds in the accounts and shut down the. Then there's some targets that aren't good for Schedule A litigations for a variety of reasons. Some of them may be U.S. businesses that you can't really make a colorable argument to the judge that they'll run away because they have an established presence here, or it looks like they're not really bad actors. Maybe they weren't aware, or maybe it's not really intentional. A cease and desist letter may be better. There's a variety of reasons why, but really just being able to distinguish the two, because one of the worst things that could happen is, not the worst thing, but you want to try and avoid mixing defendants that will actually appear in court and fight, where you're sending C&Ds, trying to settle with as many as possible there. And then whoever's left over, really working with the client on which ones are we going to actually sue in court and do litigation against. And for everything else, mass takedowns. This piece depends on the client. If this continues to work, they sometimes will filter through these two things and hold off on takedowns later. But pretty much once you file your first Schedule A litigation, word is out there and the infringers know, so they will try to move money out of the accounts, which is why sometimes it is better to prioritize these cases and hold off on takedowns. And so this is like our combat piece, which is why I skipped. But Amplify is then, work with customs, don't just do IP, train them, get the word out, get other people to help you enforce, work with the brands, work with TikTok, Amazon, Alibaba. Usually what's really helpful is having relationships with them. We have platforms that they're like, if you give our emails away, we're not going to answer you. We're not going to answer the people you've sent it to. So there really is, I straight up at INTA, one of the platforms told me, you're one of 3 lawyers that we work with. We have no obligation to work with lawyers. So a couple things, you want to make sure that the lawyers you're working with, if you're going to escalate, have a real relationship with the platforms. But number 2, they've told us it's wild the amount of hate that we get from other lawyers. So you do get more flies with honey if you're sending nasty emails to the people there. They're lawyers just like us who it's their job. They're trying their best. They really are. And if you're yelling at them while trying to ask for something as a favor, it's probably not going to go well. And then we talked about this, public relations, using press and social media. Okay, and I have this slide talking about what Schedule A is. So feel free to screenshot this, or you can, I have the recording you could save. But this is the process that I talked about. Yeah, so this is just, using these platforms. We literally had clients waking up at 3 a.m. The spreadsheets is a nightmare, and we want clients to focus on growth and while brand protection stuff. And that's it. That's super egregious, and they have a U.S. presence, and you really want to take them to court. maybe doing a cease and desist letter first is appropriate. So putting those targets in that bucket